Get ready. Start. The Supreme Court held that mere failure to disclose assets in the affidavit, if it does not constitute a material defect and is not of a substantial character, will not make the acceptance of the nomination improper, thus invalidating the election. Stop para. Such a failure will not amount to a corrupt practice as per section 123 of the Representative of People's Act, 1951 within bracket RPA to render an election result void as per section 100 within bracket 1 within bracket B. Stop para. Holding so, the Supreme Court refused to interfere with the election of the Bharat Rashtra Samiti within bracket BRS MLA Koa Lakshmi, who was elected from Asifabad constituency of Telangana Legislative Assembly elections, 2023. Stop para. Upholding Lakshmi's election, the bench comprising Justices Suryakant and N. Koteswar Singh dismissed an appeal filed against the Telangana High Court's decision, which refused to interfere with Koa Lakshmi's elections. Stop para. Koa Lakshmi had disclosed her assets, liabilities, PAN, and sources of income bracket honorarium as Jila Parishad chairperson bracket close. Stop. C also submitted IT returns for 2022 to 2023 but recorded nil income for previous years, that is, 2018 to 2022. Stop para. It was alleged by the appellant Azmera Syam that the omission to reveal her income details as per Form 26 affidavit amounted to improper acceptance of nomination and corrupt practice under section 100 of the RPA, for which her election is liable to be set aside. Stop para. Rejecting the appellant's contention, Justice N.K. Singh, in a detailed judgment, observed that though Rule 4A of the Conduct of Election Rules, 1961 requires candidates to file Form 26 affidavits disclosing assets, liabilities, and IT returns of the past 5 years, the non-disclosure of the same would not be a substantial defect so as to declare the corrupt practices. Stop. Disclosure requirement as far as assets and educational qualification is concerned, should not be stressed to invalidate an otherwise validly declared election over minor technical non-compliances that are not of substantial character, comma, and should not be the basis for nullification of the people's mandate. Stop, comma. The court said, para. The defect of non-disclosure mentioned is not of a substantial nature, comma. For the same reason, the respondent number 1 cannot be considered to have indulged in a corrupt practice within the meaning of section 123 within bracket 2 of the act, comma, and thus, comma, the election of respondent number 1 cannot be rendered void under section 100 within bracket 1 within bracket b of the act. Stop, comma, the court held. Stop, para. The court noted that in Lok Prahari versus Union of India and ORS within bracket 2018, comma, it was held that if it is found that there has been non-disclosure of assets, comma, it can amount to a corrupt practice. Stop. However, comma, as regards the present case, comma, it observed, para, the non-disclosure of income as per income tax return in the present case, comma, as discussed above, comma, is not of a substantial nature to be considered a corrupt practice. Stop, para. The court noted that the lapse to not file the IT returns for earlier years did not constitute a corrupt practice under section 123 within bracket 2 RPA, comma, unless it is shown that such concealment or non-disclosure was of such magnitude and substantial nature that it could have influenced the election result. Stop.